Well, welcome everyone. My name is Eric Priest. I am a professor here at the University of Oregon School of Law, and I am here introducing this event as the chair of the committee at the University of Oregon School of Law on Lectures and Awards, which has organized this event. So this is our annual Constitution Day program. As you may know, Constitution Day is a celebration of the anniversary of the date in 1787 on which the Constitution was signed by the Constitutional Congress. The event today is titled National Security in the Constitution, Reflections on Constitutional Issues Raised by Wikileaks, Cyberspying, and the War on Terror. And I am very pleased to present my three colleagues here from the University of Oregon who will be speaking about these issues. First, Professor Dave Frohnmayer, who's a professor of law here at the law school and University President Emeritus, will make some general remarks about the Constitution, followed by my colleague Ofer Raban from the law school here, who is an associate professor, and also Elmer Sahlstrom, Senior Faculty Fellow. And then I am pleased to present Dan Tichenor, who is from the Political Science Department. He's Philip H. Knight Professor of Social Science and Senior Faculty Fellow at the Wayne Morse Center for Law and Politics, which is housed here in the law school. So without further ado, Professor Frohnmayer.
Thank you very much, Eric, and thank you all for coming for this annual day of celebration and renewal, and at least in terms of my part of this program, a devolution back to not quite elementary civics, but reminder of the structure, the underlying structure of constitutional powers and guarantees that makes up our political system, which is continuously in evolution, sometimes baffling to understand, but nonetheless a piece of our daily political life and hopefully our enduring future. I want to take maybe 5 minutes, and if I trespass beyond that time, I hope I'll get some friendly reminders from the audience, just to talk about some of the structural underpinnings that will be, I'm sure, referred to by the speakers who followed me. And this reminder probably is good for us. In my view, there are 3 architectural principles of the United States Constitution. The first is something that generically goes by the term federalism. That is to say, a geographic allocation of powers as between the national government and state governments. It is a traditional battleground of ideologies as well as legal doctrines, but it's structurally built in both to the body of the Constitution, including a term that's sometimes used by the courts that my former colleague here, Hans Lindy, would very much object to, a notion of police power that remains in the state building blocks, and a 10th Amendment, which reserves powers not allocated to the federal government to the states. And the question has always been in modern constitutional law whether that 10th Amendment really is an allocation of power or simply the statement of a truism. Were we talking last June and talking about Obamacare or the Affordable Care Act, we might have been talking about where the commerce power collides with the body of the Constitution, but in an opinion by just narrowly deciding the court, the taxation power was seen as, in essence, trumping whatever residual powers might limit Congress in this regard. Because of the provisions of Article 1, Section 10 of the Constitution, which fundamentally, in my view, deny the states foreign policy powers, we basically will leave this building block of the Constitution for discussion another day, today when we're talking about national security affairs. On the other hand, we're intimately concerned with the allocation of national power, which is among 3 separate institutions. This sometimes goes by the rubric of separation of powers, although separation of powers, that term does not appear in the United States Constitution. And the powers aren't really separated. The institutions are separated, and they share powers, something that we'll talk about in just a moment because it's a key structural provision of the Constitution. But bearing on today's discussion of national security is a full array of legislative powers that Article 1 confers on the Congress. The commerce power might be used to justify some kinds of legislation that reach into the lives of American citizens, and in the foreign commerce clause obviously reaches our relationships with other nations. The taxation power, foreign commerce, customs power, the power of treaty making shared actually with the president, the power to declare war. Interestingly enough, in the founding convention, those words were changed from make war to declare war. And whether that has significance, we do not know. But the Constitution entrusts armies, the raising and provisioning of navies, the guidance of militias to the Congress, and it has this generalized necessary and proper clause that was, again, the subject of much jurisprudential dispute in the ACA decisions last June. Article 2 establishes the executive power. And objectively speaking, looking at the text of Article 2, one could never divine the extent of authority exercised by the President of the United States President. Powers that have grown basically by delegation from Congress rather than in the text of the Constitution, because it's pretty sparse. It vests the executive power. Now, is that just a description of the rest of the powers that follow, or is that something else? Again, a matter of continuing dispute. The President is Commander-in-Chief. The President can, big deal, command opinions from his officers as to the conduct of business, and that clause, that article has a faithful execution clause. That's it. In terms of what the President's power are, as the text of the Constitution might explain. Article 3 provides for, of course, as we know through the history of the United States Supreme Court, judicial review. But in general, in national security matters, and this is a on-again, off-again doctrine, kind of a hands-off judicial view of it. In terms of foreign policy, Lewis Hinckley, who was last generation's leading authority on the Constitution and foreign affairs, says that the text of the Constitution is hopelessly ambiguous about the extent of national power in national security matters, because some matters are entrusted to the President, some to the President and Congress, some, as in the ratification of treaties, to the President and the Senate, some to the President or Congress, and some are exercised jointly. This morning's morning paper carried the story that Joseph Lieberman, the former senator from Connecticut, has argued that with the existence of the War Powers Act, that the President basically unilaterally could declare war, or could make war in Syria without the further consent of the Congress. So in cases where the powers are acting jointly, they act with the full authority conferred by the Constitution. But that's not the end of our story. I'm sure that our speakers today will talk about the limitations on government power generally, expressed both in the body of the Constitution, provisions for the maintenance of habeas corpus, not suspending except in times of emergency, an issue that first arose, I think, distinctly in the presidency of Abraham Lincoln, literally 100 years ago, more than that, 150 years ago. The Bill of Attainder prohibition, the prohibition against ex post facto laws, and maybe more generally, and this is where I'll conclude my remarks, a series of amendments to the Constitution, which we characterize as the Bill of Rights. At least more than a half dozen of which I think might be directly relevant to today's discussion. The First Amendment, for example, protects liberty of the press, and those of you who have either read of or some of us can remember the Pentagon Papers case, the First Amendment's been construed very broadly to prohibit prior restraints of the written media or its surrogates and proxies. The Fourth Amendment's prohibitions against unreasonable searches and seizures and the requirement of warrants for searches are obviously relevant, although how they are relevant, to issues of the seizure of private communications through the internet, as we've discovered the National Security Agency has been doing with some dispatch and thoroughness recently. That's implicated, the Fourth Amendment. The Fifth Amendment provides for due process and a whole array of procedural and substantive protections. The Sixth Amendment provides us for speedy trials and the right to counsel in the case of criminal proceedings. The Seventh Amendment provides for jury trials. The Eighth prohibits cruel and unusual punishments relevant to torture debates, I would suppose. And the Ninth Amendment In a flirtation by the court nearly a generation ago, it is suggested may preserve some nascent right to privacy, some notion of bodily integrity, personal integrity that emanates from the Constitution itself. So that's our structural overview. It's a hop, skip, and jump through constitutional structure, but I hope it sets the foundation for our distinguished speakers, to whom I now yield. Thank you.
These are not particularly informative slides, but they do give you the opportunity of staring at something other than me. All right, let's start. I'll start with some history, some recent history. Shortly after September 11th, the Bush administration initiated a secret surveillance program that apparently violated both the federal statute and the federal constitution. The program went on for several years in secret and was finally disclosed by the New York Times in 2005. The New York Times, by the way, sat on this story for a year before eventually publishing it. When he did publish it, the Bush administration called the disclosure illegal, threatened the New York Times with criminal prosecution, and then claimed that the program was perfectly constitutional. But in 2006, a federal district court found that the program violated no less than 3 constitutional provisions. First, the court held that the program violated the 4th Amendment, protection against unreasonable searches and seizures, because it conducted surveillance without the required judicial approval. The court also held that the secret surveillance program violated the First Amendment because it chilled the speech of those who were subjected to these surveillance activities. Finally, the court held that this program violated the separation of powers principles of the federal constitution, and it did so because the program failed to follow the procedures that were laid down in a federal statute called FISA, the Foreign Intelligence Surveillance Act, that was enacted precisely in order to regulate surveillance activities on the part of the executives. FISA was enacted in 1978, and it followed the disclosure of awfully lots of surveillance abuse on the part of the Nixon administration. FISA also established the so-called FISC, or the Foreign Intelligence Surveillance Act Court, which is a secret court that, responding to government's requests, can issue warrants and orders of surveillance. Now again, following 9/11, the Bush administration simply ignored both the FISA statute and the FISA court and conducted its activities irrespective of this statute. So again, this district court declared that the program was in violation of the Constitution, and it ordered the program stopped. But this decision was soon reversed by the Sixth Circuit Court of Appeals, which reversed the decision for lack of standing on the part of the plaintiffs. So for those of you who are familiar with the term, standing is a constitutional requirement for the federal courts, and the court held that the plaintiffs in the case could not establish standing so as to challenge the constitutionality of the secret surveillance program, and it reversed the decision. Now, again, the Sixth Circuit did not decide that the program was constitutional. It simply dismissed the lawsuit for a lack of standing, which again is a constitutional requirement. In 2008, Congress revised the FISA statute, and it did so precisely in order to try and make sure that the secret surveillance program is at least compliant with the federal statute. So 2008 is a revision of FISA that tries to bring the secret surveillance program within the confines of this federal statute. Of course, if the program is unconstitutional, Congress could not authorize it, because you need a constitutional amendment for that. Unfortunately, it has proven impossible to get an authoritative statement as to whether the program is constitutional or not, because courts keep dismissing lawsuits that challenge the constitutionality of the secret surveillance program on grounds of standing. The most recent iteration of this position was just this term in 2013. The court issued, the United States Supreme Court issued a decision, yet another decision that dismissed a challenge to the secret surveillance program on grounds of standing. This was a 5-4 decision divided along the familiar conservative-liberal divide. The 5 conservative justices again reversed the decision of the Second Circuit that did find standing. The Supreme Court reversed that decision and held that the plaintiffs in the case could not establish standing because they could not actually prove that they were subjected to surveillance. Of course, it is unknown whether they are subjected to surveillance because the government refuses to disclose that information, right? The government does not deny that it conducts surveillance activities on the plaintiffs in the case. It simply says that it refuses to disclose the information and the information is secret. And the Supreme Court accepted the argument and then said, case dismissed because these plaintiffs could not demonstrate that they were in fact subjected to surveillance activities. Again, the result of this and the other decisions that dismiss those lawsuits for lack of standing is immunizing this vast surveillance activities from a constitutional scrutiny. Now, just how vast these surveillance activities are, we recently learned thanks to the help of Edward Snowden, this 24-year-old computer specialist, who released awfully lots of classified documents to the press. What we learned from these disclosures, among other things, is that the government collects metadata practically on all telephone calls made in the United States, and that it also collects vast databases of electronic communications, email communications, and internet chats that it stores for cases where it wants to scrutinize and use that information. Now, anybody who followed these secret surveillance programs and the legal challenges to them over the years knew that these programs are vast and that they probably spy on awfully lots of unsuspecting Americans, but practically everybody was shocked by this indiscriminatory dragnet surveillance that Edward Snowden exposed. This exposure followed by some immediate lawsuits that were filed with the courts. And these lawsuits, again, that were filed in recent months, challenge various aspects of this surveillance program. One aspect was a challenge to the order that authorized, this is an order again that Snowden released to the press, an order of the secret court that authorized the collection of the metadata regarding domestic telephone calls. The order was presumably justified based on the business record provision of the amended FISA, but many commentators think that in fact the statute authorizes no such thing, not based on its language nor based on its purpose. Then of course there is the question of the constitutionality of the program, first under the Fourth Amendment, insofar as the program is collects awfully lots of private information. Now, the apparent justification for the program under the Fourth Amendment comes from a 1979 case, Smith versus Maryland, where the Supreme Court held that people have no reasonable expectation of privacy in the telephone numbers dialed from their homes. But many commentators think that that decision is outdated. It was decided in a world that is very different than ours, where electronic communications were much less pervasive, and also that recent precedents undermine the validity of that decision. So there is a challenge to the program based on allegations of violations of the Fourth Amendment. Then there are also some challenges to the very authority of FISC, of this secret court. The ACLU recently filed a lawsuit claiming that these FISC orders were unconstitutional because they are essentially advisory opinions. Those of you who took constitutional law know that advisory opinions are prohibited by Article 3 in the case of controversy requirement. And the argument here is that these orders are so abstract and they do not concern any particular case or individual. They're just blank, indiscriminate authorities to conduct dragnet surveillance, that they in fact constitute advisory opinions in violation of Article 3. Another lawsuit claims that the court orders in fact violate the First Amendment because they violate the constitutional right of access to the court. The United States Supreme Court, in a series of decisions, recognized that we have a constitutional right of access to open courts. And the claim here is that this secret court, that in fact issues very important decisions about constitutional law, violates this First Amendment protection. For all we know, this secret surveillance court is indeed a rubber stamp. Let me give you some numbers. In 2011, the government submitted 1,676 surveillance applications to the court. 1,674 were approved, 2 were withdrawn by the government. In 2012, the government submitted 1,856 applications, all were approved. So there is something distinctly Orwellian, if you will, about this court that issues decisions after representations only by the government, and then on top of that keeps these decisions secret. Let's turn more fully to the First Amendment. Let's start with the recent prosecution and conviction of Chelsea Manning, who was sentenced to 35 years in prison for releasing documents to Wikileaks, documents that then Wikileaks posted on the internet. Among other things, Manning was charged with aiding the enemy. This is a capital offense under the military code. It is an offense that carries the death penalty. The specific charge was that Manning aided the enemy by releasing documents to the enemy indirectly. That is, Manning gave documents to Wikileaks, Wikileaks posted these documents on the web, and then the enemy accessed these documents. Now, when the prosecutor in the case was asked whether it would have made any difference if Manning would have released the documents to the New York Times rather than to Wikileaks, the prosecutor said, no, the same charge would stand. The military judge accepted this interpretation of the law. It held that this interpretation of the law is indeed correct, and this military judge also rejected the motion by the defense that tried to limit the charges of aiding the enemy only to instances where the defendant intends to help the enemy. That is, the defense says, in order to be guilty of this capital offense, one needs to have the intention of aiding the enemy. The judge said, not so. It is enough if you have knowledge that the enemy will access the information. So, if Manning released documents to Wikileaks, Wikileaks posted these documents on the web, and Manning had actual knowledge that the enemy was accessing this media, or the New York Times for that matter, then he could be found guilty of this capital offense of aiding the enemy. Of course, many people think that this interpretation of the law blurs the distinction between leakers and spies. Now, Manning was also charged and convicted of violations of the Federal Espionage Act. This is an act that was enacted in 1917. And since 1917, until the Obama administrations, there were only 3 prosecutions of government employees that released classified information to the press. Since Obama took office, there were 7 such indictments, including the indictment of Edward Snowden, who was indicted in June for violations of the Espionage Act. This is a very handy way of handling government leakers, and of course it threatens to shut down many sources of investigating journalism. One prosecution under the Espionage Act involved the leaking of information regarding some botched CIA operation in Iran to James Raban of the New York Times, the same fellow who in fact was involved in exposing the secret surveillance program. Now, the government sought to force Raban to disclose his source regarding this leak of CIA operation in Iran. Raban refused. There was a decision by a district court that held that Ryzen could be forced to release his source only if the government could show that there was a compelling interest in the testimony. And according to the district court, the government failed to make that showing in that particular case. This decision was reversed by the urging of the Obama administration this July by the Fourth Circuit in a 2-1 decision that held that journalists have no First Amendment protections whatsoever against forced disclosure of their sources in criminal trials. Again, this is an argument that was made by the Obama administration and was accepted by this panel of the Fourth Circuit Court of Appeals. More outrageously, if you will, it was recently disclosed that the administration went further in 2010. This was another Espionage Act prosecution that involved a journalist named James Rosen from Fox News. He was given some information by a government contractor regarding North Korea's nuclear program. And as was exposed recently, it came out that the government searched his emails and in the search warrant application named Rosen as a co-conspirator and an aider and abettor in Espionage Act violations. In other words, they called this journalist a criminal for violations of a law where the penalties can be dozens of years in prison in order to obtain a search warrant for his emails. Finally, let me finish by mentioning the Associated Press scandal that was also exposed recently, where it came out that the government, investigating another leak, in fact seized the records of more than 20 telephone lines that were assigned to the Associated Press, telephone lines that were used apparently by more than 100 journalists, many of whom were, of course, writing about the government. The government again seized these lines and searched through 2 months' worth of records of 20 telephone lines in its investigation of this leaked information. So, in short, dragnet, electronic surveillance, a secret court shaping important constitutional protections, government leakers prosecuted as spies, and journalists searched as criminals. This is the constitutional landscape that is created by a constitutional law professor. Unlike his predecessor, Obama should know better. Thank you.
So thank you for having me here today. I'm glad to join this conversation about, which I kind of did. It's supposed to be focusing on the genius of the American Constitution. But I have to say I'm going to be taking a irreverent note by focusing on something in particular that Professor Frohnmayer honed in on, which is Article 2 of the Constitution. That is, to spend some time thinking about executive power and its origins and development, and how it got to the kind of things that Ofer was talking about. Where I want to start on this is actually by talking about just how long it took the framers of the Constitution to actually frame Article 2. It was one of those issues that they dreaded. They spent a lot of time with the great compromise over representation and the shameful compromise over slavery. They spent a long time on Congress and so on and so forth. And it wasn't that they got to the issue of the presidency as an afterthought. They got to it late because they were dreading the topic. It was one of those things that was like, after a good meal, not wanting to do the dishes, they didn't want to get to it. And there's a long story I could provide about how, among the 55 framers, why so many of them really were uneasy about addressing this issue of executive power. But suffice it to say for now that there was a great deal of disagreement about what to do about executive power. And there was a lot of unease about the person who was presiding over the convention, was George Washington, the person they expected would become the first president. They didn't want to offend him, but they all had an enormous dread about this office. The upshot is that what we got out of the Constitution is, as I think Dave captured really well, is something that is very vague. That is, the executive power is something that's often described by scholars, left, right, and center, as a wild card in that parchment. And as a result, and actually if you look at Publius, the schizophrenic Publius, Hamilton, Madison, and a little bit of John Jay, you can see on this issue in particular the split personalities of the constitutional framers. For Madison, in the framing of Article 2, what was, in his view, what you were doing was creating an independent, competent branch of government, but one that would be strictly limited by the letter of the law, that would not go beyond particular prescriptions or powers spelled out in Article 2 or in congressional statute, as opposed to Alexander Hamilton, his partner in crime in advocating the Constitution, who envisioned something that was much broader. That is, that there were, within this executive power, there were significant inherent authority that was being established. Room for, as Teddy Roosevelt would describe later, for a president to be an energetic steward of the public interest. So fast forward, you get to George Washington's administration. I mean, not that fast forward, but and you get into this heated debate that comes forward over Washington and his neutrality proclamation. And without getting into the weeds of what was going on in international affairs at the time, what incensed Jefferson and Madison at that historical moment was the fact that Washington was not asking Congress to intervene in that decision, but instead was unilaterally staking out what the U.S. security interests were in that particular issue. And that then spurred a very heated debate where the authors of the Federalist Papers go public against each other on this question of whether the presidency should be understood as something that's strictly constructed, or whether, in fact, Article 2 created broad powers for the executive. And so that then became something famously known as Helvidius Pacificus debates. And by the way, why did they use pseudonyms at the time? Instead of saying Hamilton and Madison, they did duels back then. So if you offended someone in public, you might get shot, as Hamilton would find out later, right? What stands out is that after this initial founding, Article 2 of the Constitution is set up so that there's a significant elasticity to it. So that in certain hands and during certain moments and crises, that executive power is stretched significantly. But then in other moments, it then returns to something that's much more narrowly constructed. Quick point I want to make. Two metaphors. One is Jeffrey Stone's in describing war and liberty and thinking about the role of presidents in that context. He notes in his descriptions of civil liberties during our most perilous times that he suggests his metaphor is one of a pendulum. And that is, before the war, the Bill of Rights are robust in his formulation. Basic freedoms trump security and that liberty-security balance. But then when we enter the wartime crisis, particularly the ones in which we perceive ourselves in being in the most grave danger, in his rendition, the Civil War, World War I, World War II, and has updated that to the War on Terror. The suggestion is the pendulum then swings from liberty to security, but that once the crisis is deemed over, it goes to status quo ante. That is, the pendulum swings back. A key point that I want to make, and why I think that metaphor is deeply flawed, is that I think that works fairly well for the Civil War. We can find lots of examples about how extraordinary powers that are seized by Lincoln in that context, in fact, after the war, swing back. But I would suggest that with each of those crises, we see the pendulum swing, but each time it swings back less and less. Second quick metaphor I want to throw out there is Robert Jackson's from the Korematsu dissent, in which he suggests that when precedents are set for executives to use certain powers, like your 1917 example of Wilson and how he used the Espionage Act, that it sits like a loaded gun on the counter for subsequent presidents in similar circumstances to use it. Okay? Now, parting to a fourth really quick point I want to throw out, which is that what's missed, I think, in both the pendulum metaphor and the loaded gun on the counter is that it doesn't capture a steady accretion of executive power that we've seen since World War II and the Cold War. That is, what we've seen is over time, an expansion of the national security state and a trend, a very steady trend, in which presidents have been ceded enormous power as commanders-in-chief to, in fact, as Dave pointed out, the constitutional construction was that the war powers are going to be strictly divided between Congress and the presidency. What's happened clearly since World War II has been that presidents have exercised enormous autonomous power over the conduct of war. And that, more importantly, Congress has retreated in its obligations to act as a check in numerous cases in this regard. Here's a tease. I don't have time to get into this, I'm going to give a quick tease. In this regard of seeing an expansion of presidential war power, I just read a recent article where someone was talking about Barack Obama being the fourth term of George W. Bush. And it might be more appropriate to describe him as perhaps the 21st term of Franklin Roosevelt, if you think about this steady expansion of executive power. But the tease is that, and I think our goal with Roundtable, right, where we have some discussion, is, so I hope someone will ask me about this, which is, Obama is not a carbon copy of George W. Bush on these issues, despite the national surveillance, the NSA surveillance program, despite the drone targeted killing program and so forth. And so it might be, I think, useful for us to talk about perhaps some distinctions between Bush and Obama and say, are there distinctions that make an enormous difference? I think they are, but I think it's something that's very open for debate. And as a last point is to turn the focus back on us. One of the things that strikes me in all of the heated debate surrounding some of the issues that Ofer was talking about, and about the war on terror, is that most Americans express great distress, especially as we moved away from 9/11, about invasions on privacy, especially associated with surveillance of communications networks and so forth with NSA. And also great concern about drones and the technology that represents. But when you look at the polling in this regard, what is particularly striking, and I think rather disquieting, is that most Americans are the most distressed about invasions that affect the broadest number. Not necessarily the most acute and abusive intrusions of the national security state on human rights and civil liberties. So two quick examples. On the drone issue, the largest amount of public opposition to drone technology is the notion that they might be used to track us for speeding tickets and to be used domestically. There's not been a great deal of opposition to the notion of using them for targeted killings, the so-called kill list that the White House currently operates. And then the other kind of contrast that really stands out and galls me is between the enormous amount of furor and disquiet surrounding the surveillance program, and at the same time, most Americans are not terribly bothered by the fact that Guantanamo Bay is still open. Still has 166 people who are there, 86 of whom have been deemed as no security risk and yet are not released. I think I could give you lots of stats on this, but I think the youngest person at Guantanamo Bay is 13 years old, the oldest is 84. But Americans are not particularly worried about these things. So on that note, we'll turn it over for some questions.
Great. Yeah, so as Dan mentioned, we'd like to open it up for questions and get a discussion going, have sort of a roundtable feel.
Margaret, yours is the first hand.
Well, just following up a bit on Dan's point, I'd like to hear from others that it seems to me that I don't understand the legal basis for the effect on our citizens and what we can do to and about citizens of other countries. And it seems like in a lot of these issues that you're talking about, the surveillance and the drones and the like, we feel like we have this privileged position as U.S. citizens. which bothers me a lot, and I think that's why people are concerned about being spied on for their traffic rather than somebody sitting in a prison or in fact being killed abroad. So can you just touch on that a bit?
Well, there's a frame shift, it seems to me. We used to think of foreign policy and war as something that is extracontinental, that it's international, that it doesn't affect us. And I think one of the points that both of my co-panelists made very acutely is blurring the distinction between foreign domestic conduct and government activity. And a point that I think is implicit in, but maybe needs to be made explicit, look at whom the government has drafted to help in this process. They're some of the largest internet and web-based companies in the history of the world. They give orders to Google to do stuff. So it's not only turning to the domestics, what used to be regarded as the domestic front, it's also mobilizing a vast array of non-governmental resources to do the government's espionage business. And that, it seems to me, is quite unprecedented and has occurred so glacially, maybe, that we haven't really stopped back to assess how totally mobilized our society is and how totally we've erased the foreign domestic distinction.
It is also a line that, although it has legal foundation, is being blurred. So, for instance, with the targeted assassinations, it was explicitly said that there is authority to assassinate American citizens, and it was defended as such, to the extent in which it was defended. Supreme Court decisions regarding enemy combatants, the Supreme Court did draw a distinction between the rights of American citizens and non-citizens. Nevertheless, even American citizens can be detained as enemy combatants, potentially for life, insofar as hostilities continue. They deserve some constitutional protections, but the Supreme Court said as enemy combatants, they certainly are not entitled to the full protections of a regular criminal trial. And so you certainly see the erosion of these constitutional protections affecting citizens as well.
I think the distinction is less between citizens and non-citizens, although that's often quite relevant, but more about how us versus them is defined in different contexts. So, I mean, you could look at public opinion polls during World War II and look how folks responded to things about Japanese internment, and overwhelming majorities were fine with that. Likewise, if you look at right after 9/11, when you had mass roundups of Arab and Muslims who were non-citizens, but again, there was comfort with that, so there was a citizen divide there. But as Ofer just mentioned, 4 U.S. citizens have died in the targeted killings. 3 of whom were not specified targets, and most of us are okay with that. Question?
Yeah, this goes to the role private companies have in working with government surveillance. This is kind of a pointed question. I might be wrong, so just give me light. My understanding was for a company like Google, where you have an email account, that actually Google owns that account. And then my understanding was that NSA basically copied entire accounts, and they have their own facilities at the NSA doing that. And my understanding is that's been around for a while. Is that true, or?
It is true, yeah. Now there is an interesting question here. First, regarding what the standard under the Fourth Amendment is a reasonable expectation of privacy. And there have been lots of lower court decisions that are all over the place in terms of whether we have a reasonable expectation of privacy in the content of our emails. There are some Supreme Court precedents that said, well, insofar as this is something that was released to a third party, such as Google and its servers, we no longer have a reasonable expectation of privacy in these emails, such that the government can scrutinize our emails without the need for a warrant and the protections of other protections of the Fourth Amendment. There is lots of disagreement about this question. Then there is also the Fourth Amendment rights, if you will, of companies like Google, when the government comes to them and says, now we want to copy the content of your servers. And indeed, it was only thanks to the disclosures of Edward Snowden that companies like Google started pushing back and perhaps insisting on their own Fourth Amendment rights in terms of the government, again, insisting on putting its hand into their property, if you will. But there are indeed two interests that are involved here under the Fourth Amendment: the interest of the people whose email accounts are being scrutinized, the Fourth Amendment interest of the companies that hold the information. And then, of course, there is also the question of under what circumstances the government, in fact, goes ahead and makes use of that data. So, for instance, with the metadata of the phone calls, the government says, again, we have little way of knowing to what extent these guidelines are being followed, but the government says that it goes ahead and analyzes the data only when it has a reasonable suspicion of terrorism-related activity regarding a certain individual. So that they keep the data, but don't make use of it until there is such reasonable suspicion. So these are all, again, we do not know authoritatively how the program works, but these are all issues that, of course, affect the constitutionality of all these activities under the Fourth Amendment.
Let me just quickly plug a scholar who I think does the best work in this area. This is someone named Margaret Hugh, the Wayne Morse Center had come last year. She's at Duke Law, and she's done really fascinating work about that thinks about both the jurisprudence on this subject that you're discussing, but also the development of technological capacities, both in government and outside it, for big data, and how that reflects a much longer trend that stretches back to the 1990s that we've become much more acutely aware of more recently. But it's really powerful analysis that I highly recommend.
Yeah, it's like what's the difference between a phone conversation and to me they're really similar, like a phone conversation and a personal email.
Well, the government collects metadata, not the content of those conversations. That is to say, under this surveillance program that was exposed, the government collects the times of the call, the numbers that are dialed, and possibly the location, where the location of the person making the call is and the person receiving the call. This is metadata. This is not the content of the actual conversation.
Question here.
How do you turn the tide? I mean, it's clear, at least...
How do you determine what?
How do you turn the tide?
Turn the tide.
It seems you all have a consensus that there is either a progression or an erosion of rights provided by the Constitution. And I think the question for me is, how do you change it?
You hold constitutional day events.
Well, I think just a quick comparative constitutional notation. The Oregon Constitution, which we all should read from time to time, has a specific provision. No court shall be secret. And secret courts do not have a good reputation in history. From Roman times to the Star Chamber and so forth. So I am troubled by and interested in Ofer's view that secret court opinions are advisory opinions forbidden by the Constitution. But even notwithstanding that, as long as the courts have a hands-off view, as long as they use standing arguments with such surgical precision, you're not going to get the case or controversy before the court that will pose the issue. So I think it's an issue.
I always basically say elections matter, and debate within elections matter, and Ofer's quite right with this slide when he pointed to Obama, constitutional law professor, but he is a constitutional law professor who does know better, and I'll just briefly say, there were no great surprises on this issue. He controversially, during the summer of 2008, voted for the National Security Agency's surveillance program. What's striking is that as he's had a maelstrom of criticism, he's come forward more recently in a very un-Bush way with suggestions for making the process more transparent, declassifying more things, having an outside panel review and just great oversight, talk with Congress about revising the Patriot Act's article on this issue, and perhaps establishing an advocate within government who's kind of a civil liberties privacy guardian. Whether those things actually add up to enough to slow the tide or not is an open question, but the fact that he's willing to have that conversation goes well beyond the sort of Dick Cheney sort of response to challenges to the inherent power of the executive. So I think who occupies that office matters a lot, and kind of public feedback that goes into that office is also significant.
So I think
Question
we
here and then.
have time for one more question because we have to turn the class over by 1:30. That clock is about 5 minutes fast, but still, we can wrap it up.
So I have a question that I think relates to both that have been asked, and that's about the issue of encryption of electronic communication. I've heard that proposed as a way to potentially start that tide turning and fight back. But that, I guess, depends on how they're actually collecting the information. Like you said, they only analyze it at a specific, when they have specific reasons to do so. But I've also heard that, they have the keys to all these encryption technologies that we have. So, any thoughts?
This was one of the disclosures of Snowden, right? I mean, he showed that in fact the government was undermining the efficacy of these encryption methodologies, these encryption technologies, by going to the companies and insisting on some kind of a back door to this communication that they can then access if they need to. The criticism here, of course, is that this undermines the security of the internet as a whole. I mean, this backdoor can then be used by practically anybody if they have the know-how and manage to break that door, including the safety of financial information. But again, so far as we know, the NSA, as of today, has the key to practically all available encryption technologies.
I think the first question also circles back to this too, that the more you have public-private collaboration in this regard, the harder to provide a check in terms of government intrusions in this way.
I don't think you start there. I have been a public official in enough different capacities in recent years that I've just basically lost my expectation of privacy anyway. So I assume that if I'm foolish enough to launch something out there, encrypted or not, it's going to be found and misused or used by somebody. So it tends to have the chilling effect that you might expect.
Well, I think we have to wrap it up because there's a class that's ready to enter the room. So thank you again.